Hello and welcome to Schedule School Seminar 2. My name is Oliver May. I'm a personal injury and clinical negligence barrister from number 5 Chambers.
And I'm Karen Hunt, a barrister at Outer Temple Chambers. Today we have two guests with us who are going to help us prepare a schedule of laws for care and case management. Ben Bradley is a barrister at Outer Temple Chambers and one of OTC's resident schedule whisperers. He is a leading junior and acts for both claimants and defendants in high-value catastrophic injury claims.
Anna Higham is a top-rated senior associate at Stewart's and also acts in complex and high-value catastrophic injury claims.
Anna and Ben have both acted on a number of cases together. Recently, they successfully represented the claimant at trial in the case of UNAS, which was included in Mr. Justice Poole's clinical negligence blog as one of the top 5 ClidNeg cases of 2019. And they have recovered in excess of £20 million for clients over their time working together. So they are well placed to take us through today's seminar.
So just to give a brief introduction, Schedule School is a free resource hosted by junior practitioners and of course guided by senior practitioners. Everything that you see today will be uploaded to the website. Once complete, it will be a guide for junior practitioners taking schedules one step at a time, and we will look at some of the key heads of loss. Most importantly, it's interactive. The worksheets are available on the website, and the best way to use this resource is to work through it yourself.
If you haven't watched Seminar 1 yet, you might want to do that before joining us for this seminar. In Seminar 1, we looked at the purposes of a schedule, some of the key calculations that are involved and using the Ogden tables. And we also looked at how to split a multiplier, which is going to be relevant for today. I should say before we begin that Schedule School is for guidance only. Any schedule is going to turn on the facts of an individual case, and so we can't cover every eventuality in these sessions. As such, nothing in this seminar constitutes legal advice.
In Seminar 2, we're going to look at calculating claims for care and case management.
And we're still considering the case of Penny Foster. The facts of her case are available on the website, and I would suggest that you refresh your memory before watching the rest of this seminar, because of course Penny's care is going to depend on those facts. But in brief, Penny is now 37 years old. She suffered a serious spinal cord injury in a road traffic accident in March 2019 and is now in a wheelchair. After the accident, Penny spent 4 months in a spinal rehab centre. She was unable to move back home to her terraced house upon discharge because it wasn't suitable for her needs. So at the moment, she's renting an accessible bungalow and continuing with therapy. We're preparing this schedule for a joint settlement meeting to take place on the 1st of September 2021.
Read the background facts, read them and understand them, and have them to hand for context as we go through.
A few other things to have to hand for this session. You might want your facts and figures, as always, a calculator, and also up on the website we have Penny's care plan, kindly drafted by Anna, and a worked schedule of loss for Penny in Excel format, so that you can look at the entire schedule in that format, as well as the close-ups that are going to be on the slides as we get started. So without further ado, Anna, thank you and welcome. Let's get started and I'll load up the slides for Seminar 2. Anna, could you please take us through the agenda for today's seminar?
Yes, we will touch upon the foundation legal principles of care claims today, particularly the key consideration of reasonableness, but the main focus will be on taking you through an example schedule of loss. We will break it down into subsections, which are past care, including both gratuitous and paid care, future care, and we set out various commercial care examples which get more complicated as Penny ages. And we couldn't let Dan Herman have all the fun in webinar 1, so we're also going to be splitting some more multipliers today to allow for the fact that Penny would like to have children in the future and will need increased care and assistance when she does. We will then explain the role of a case manager and show you the calculations for past and future case management. Finally, we'll touch upon how to express claims for care and case management as periodical payments rather than as a lump sum.
Brilliant, thank you, Anna. And in terms of the aims for this seminar, what can the audience expect to get out of this?
As you said, Karen, I have prepared a skeleton expert care report for Penny. I've provided minimal narrative and just focused on the costings of the regimes that the expert is recommending so that we can show you how to take these figures and from there set out in a schedule the cost of someone's lifelong care needs. The amount of information in a care report can be overwhelming, but hopefully at the end of this webinar, you will feel much more confident about turning this care report into this schedule of loss. And on this slide, this is the summary page of your schedule, where the total claimed for each head of loss is set out, added together, and at the bottom of the page is the total amount we'll be claiming for Penny expressed as a lump sum. As I've said, we'll talk about periodical payments later on. And you'll see on the summary that today's topic, care and case management, is highlighted blue. And as this is the first head of loss to be explored in schedule school, I've just made up some figures for the other heads of loss for illustrative purposes.
Brilliant, thanks very much, Anna.
So before we go into the details of care claims and look at the calculations that we'll need to perform for a complete scheduled loss, Ben, could you give us the big picture, please, on care claims?
Yeah, sure. I mean, a care claim can be anything from quantifying a bit of help that relatives might have given to a claimant whilst recovering from a relatively short-term injury, all the way through to setting up highly specialised commercial nursing packages that will enable a claimant who's been severely injured to continue to maintain their dignity, maintain their independence in varying degrees, and often of crucial importance, ensure that that individual can continue to live in their own home. On those larger claims, care is obviously a big ticket, if not the big ticket item. Naturally, it is of crucial importance to the claimant, and because it's a big ticket item, it's an item that's always subject to a high degree of scrutiny, both by the other side and ultimately the judge at trial.
Now, speaking of the judge, how will a judge go about quantifying a care claim at trial? Well,
the core legal concept that cuts across really all judicial decisions on quantum is the concept of reasonableness. We've set out some of the core legal authorities on the slide for you to pause and read at your leisure. But the core points are these really. Any care claim is not a race to the bottom. And what I mean by that is a claimant is not obliged to go for the cheapest option available. Provided that that claimant can demonstrate that their care package is reasonable, that claimant should succeed in recovering the care package they seek. The focus is very much on the claimant's needs and their function. The court looks at whether, in that context, the care model is reasonable in the context of the 100% principle of compensation. That is to say, the ability to put the claimant, insofar as the court is able, of course that can be difficult in certain catastrophic injury cases, into the position that he or she was in prior to the index accident. Often that can really mean utilising the care regime to enable a claimant to do more. And provided that the costs are reasonable and not outlandish, ordinarily in those circumstances, a claimant will recover.
Thanks very much, Ben. Anna, can I ask, from the claimant's perspective, other than drafting a great schedule of loss, as you and Ben have done for us, what is your top tip for maximising the course of recovery when it comes to a care claim?
Well, a great schedule is the pinnacle of years of work. The schedule is only ever going to be as good as the evidence, and the evidence gathering takes a long time. The starting point is the witness statements. The more detail about the claimant's daily routines, what assistance she gets and from whom, the limitations her injury places on her, what she aspires to do but currently can't, etc., the more the care expert has to go on when formulating his or her recommendations. Then, if you have been able to secure a sizable interim payment for your client, you can take the next step, which is to get a case manager on board and start trialing different care regimes. You will then have the care records and the witness evidence from the case manager to show what has worked and, just as importantly, what has not worked. And all this goes towards building the case for the care regime as pleaded in the schedule. The more evidence in support, the more compelling the schedule, and as Ben says, the less likely a judge is to consider what is claimed to be unreasonable.
And Ben, from the defendant's perspective, when getting together your counter schedule in respect of costs for care and case management, what is your key piece of advice?
Again, be guided by the legal framework. My approach in any counter schedule is to adopt a stance of reasonableness, because it is very difficult for a claimant to argue against a wholly reasonable position. So again, at the risk of repetition, a counter schedule is not a race to the bottom. It's much more credible to adopt a reasonable line, but then stick to it. And that's the approach I tend to take, and I find that the very best leading counsel in the business take when they are representing defendants at roundtable meetings in these catastrophic cases.
So just as we would in our schedule, let's start by looking at past losses, and in particular, let's start with gratuitous care. Now, before we get to our calculations for Penny specifically, Ben, I think it's fair to say, isn't it, that it's not just as simple as claiming for every hour that every family member has put in providing care. Can you please explain the principles that underpin claims for gratuitous care?
Yeah, well, Ollie, there are two short points, really. The first point is this, that the claim for past gratuitous care is a claim brought by the claimant, but on trust on behalf of those caregivers. And that's illustrated by the fact that if you're ever asked to prepare an approval advice, as counsel, you'll ordinarily be asked to apportion the amount of the claimant's damages that needs to be ring-fenced for gratuitous care. Similarly, if a claimant, in fact, is not going to give the money back to the caregivers, well, then in theory, they are not entitled to claim gratuitous care on their behalf. So it's important that solicitors also take instructions on that point and understand the importance of the claim being brought on trust. The second point is that really the claim is valued as if that care was provided commercially by those caregivers, albeit, and this is the crucial difference, less a discount for gratuitous receipt. We often call that the Housecroft discount, surprise, surprise, after a case called Housecroft. But it's usually 25%, that's the appropriate rate. Some claimants try and be clever and they say it's 10%. Some defendants try and be equally clever and say it's 33%, but it's not, it's 25%. And that roughly equates to what you would have to pay a commercial caregiver in tax and national insurance. Of course, because you're not paying Aunt Doris commercially, you're simply not paying tax and national insurance on any care that she might provide to you. So that's why the discount is what it is.
And Ben, looking at the two cases we have on screen now, Hunt and Severs and Housecroft, which you mentioned, what do they tell us about certain traps or limitations to look out for when pleading gratuitous care?
Yeah, there are two really small pitfalls that can sometimes catch people out early on in practice. The rule in Hunt and Severs is a straightforward one. You can't claim gratuitous care if the defendant was in fact the provider of care. So you often see that in cases where perhaps one spouse has been driving the other spouse as a passenger in a vehicle, and the spouse ends up being the cause of the accident and thus becomes the defendant. In those circumstances, you can't claim gratuitous care that might have been provided by the spouse that was driving. The second point comes from the case of Housecroft, that sets out quite a bit in respect of gratuitous care, but it's this, that your claim for gratuitous care is usually capped at the ceiling rate for commercial care. And this can often arise where a highly paid individual has, for entirely understandable reasons, given up work to look after their injured relative. And the courts in Housecroft, some may think, take quite a harsh approach there. They say, well, there may well be emotional reasons as to why you've given up your highly paid job, but the defendant shouldn't have to pay for that. Ultimately, you could have bought in care on a commercial basis at a cheaper rate, and so you can't claim your full loss of earnings as a caregiver. The claim for care is limited to what a commercial carer would cost, and that's sometimes referred to as the Housecroft ceiling.
Thanks, Ben.
Okay, thanks very much, Ben. Let's get into the numbers, shall we? Ben, could you talk us through the calculations, or rather the particular issues that are on this slide?
Yeah, so this really sort of rounds it all off. How do you calculate gratuitous care? Well, you really need three inputs. The first thing is to work out the number of hours of care that that caregiver has provided. We'll come back to that in a minute. The second is the selection of the correct hourly rate. And then the third factor is the Housecroft discount that we spoke about a few moments ago. So going through the first of those three issues, the number of hours of care. Well, how long is a piece of string? No one, of course, starts a stopwatch and times to the minute or the hour the amount of care that they might be providing to a loved one in circumstances where lives are often in turmoil and tipped upside down as a result of these accidents. So what it really is a good guesstimate as to what these caregivers might have been providing in terms of care. But you can hone that down slightly. Sometimes in a larger case, your care expert will do that for you. And then you've got their opinion as to the likely input on a plate. In smaller cases, you've kind of got to do it yourself, but you'll get a feel over time as to what is reasonable and what is not reasonable. There'll usually be an awful lot of input in those cases in the witness statement. So from solicitor's perspective, really important to get as much detail as you can in that quantum evidence about precisely what loved ones were doing, why they were doing it, the sorts of tasks. And as we'll come on to when I talk about hourly rate, when they were doing it. That's also a crucial question. And so I'll move on to hourly rates now. Relevant table is in facts and figures. That gives the National Joint Council pay scales for care at spinal column point 8. We don't really need to get into the technicalities of that today, thankfully, but as I said earlier, they're basically the typical commercial rates for care. And you'll see in that table that care rates are set out at what we call the basic rate. That's essentially daytime care in the weekday. Then a different rate for evenings, a different rate again for the weekends, Saturday being a little bit cheaper than Sunday. And then you've got two further pretty clever, helpful tables, one called the aggregate rate and another one called the day aggregate rate. The day aggregate rate is simply a combination of care given across 7 days a week, but not including nighttime care. The aggregate rate is the same principle, but it includes night care. Why is that important? Well, when I started at the bar for years, claimants would claim the aggregate rate and often actually get away with it. It's amazing how often you turn up to a roundtable meeting and you wouldn't be challenged on it. But that's not actually the right approach, because in low to medium value claims, it's very unlikely that a caregiver will in fact be providing care at night. Indeed, there are some cases, Noble and Owens being one example, another case in which I was involved called Downing and Peterborough NHS Trust, that indicate that the aggregate rate, including night care, is really reserved for the most serious of cases. But because of that, there's now another tool in a claimant's box, and that's just to apply the day aggregate rate. And you may find that that is a more appropriate rate to use in certain cases. Of course, if you're acting for a defendant and you see the aggregate rate still pleaded, well, you can really go to town on that and rely on Noble and Owens, rely on Downing, and plead that that rate is simply not appropriate.
Brilliant, thank you. So now that we have an insight into what it is we're doing when we're calculating past gratuitous care, let's look at Penny's case, let's look at a schedule and see how we're going to translate this into our Excel spreadsheet. Okay, Anna, can you take us through what's on this slide?
Yes, this slide is simply a screenshot of what your spreadsheet might look like when you are actually in Excel preparing it yourself. I want you just to note the bottom tabs where it says front sheet, summary, past care and case management, appendix 1, multipliers and future care and case management, just to show that each head of loss will have its own tab in your Excel document.
Great, thank you. And in this case, let's look at Penny, let's look at her past gratuitous care. And Anna, if you could explain to us how you calculated this and how you lay it out in this schedule, which here we've got in Appendix 1.
Yes, you will recall from webinar 1, Dan advocating the use of appendices, and I completely agree. I've used an appendix for Penny, even though Penny's calculation is very simple, because it's good practice to get used to siphoning off these calculation tables into an appendix and then just drawing the total claimed back into the main body of the schedule. So Penny's care expert has calculated how many hours worth of gratuitous care has been provided to Penny since her injury. The provision is likely to fluctuate. If someone's an inpatient, they will need less input from their family than when they first go home. And then for the first few months back at home, the family might be on hand 24/7, and then it might level out, only to spike again if the claimant gets ill. So the care report will divide the time periods and the amount of care up accordingly. There might also be multiple people providing care to the claimant, in which case they would probably have a calculation table each in the appendix. But Penny's claim is simple. It's split into only 3 time periods on the basis that just one person has been providing this gratuitous care to her. So there's 4 months in inpatient rehabilitation, a time at home from July 2019 to the end of March 2020, and then from the 1st of April 2020 to the date of the schedule, which we have said is the 1st of February 2021. So all you have to do is follow the time periods laid out by the care expert. So as you can see from the screenshot on this slide, in the first row of your table, you copy over the numbers. So 4 hours a day for 122 days is 488 hours in total. Multiply that by the hourly rate, and then that gives you the total claim for Penny's inpatient period. And you do exactly the same for the next 2 time periods. One thing to look out for is the hourly rate increasing. You will find the details on page 384 of the current Facts and Figures book, this lovely silver one for their Jubilee. Facts and Figures always has a table of the National Joint Council pay scales dating back to 1998 and bringing you up to date. And the increases usually apply from the 1st of April. So just make sure when you're doing your calculations that you apply the correct hourly rate for the time period claimed. So that's the appendix. So on the next slide, you will see that we're back to the main body of the schedule. And you'll see that the claim for past gratuitous care will comprise mainly narrative. You can read this slide at your leisure to see how you may choose to word this section. I would suggest that you insert some pithy narrative without copying huge swathes of the care report or the witness statements. Then say that the calculations as per the care expert's report are set out in the appendix. You only then need to pull through the total from the appendix, apply the Housecroft discount, and the section of the schedule for past gratuitous care will actually be quite short. Only deducted 15% for gratuitous care. Our Back to Basics webinar is not the place to go into details, and I don't think anyone needs to see Ben and I arguing over this. I agree with Ben, the Housecroft discount will usually be 25%, and it almost certainly would be in pennies. But there are exceptional cases with strong evidence for a lower deduction. And if you have one of those cases, which I will remind Ben that he and I did, it is worth pleading. So I only put that into pennies schedule here just to flag that up as a point of consideration for you.
Example of where counsel thinks he's right and then of course is corrected by his more knowledgeable instructing solicitor, and it emphasises the teamwork approach that works so well in these larger claims.
Finally, for those of you less familiar with Excel, I have set out on the next slide how to pull information from one tab into the next. I would suggest that you pause the webinar here, open an Excel spreadsheet, create 2 tabs, and follow the directions set out on the slide and see for yourself how it works. And I think that will be more effective than me simply explaining how to do it now.
Brilliant, thanks Anna. So there what we've done is we've looked at how the past gratuitous care costs break down hour per hour, how they're going to look on our summary sheet, and also here we're looking at how to actually manipulate the figures in Excel. Briefly, Anna, then, in terms of any past paid care that Penny received, how do we put that into our schedule?
Now, this should be a very simple process if you have employed the good practice as explained by Demi in webinar 1, and you've been keeping a rolling file of care and case management invoices. You simply list all the invoices in your appendix and pull the total through into the schedule. In this schedule, you'll see I've added a 3rd column into the appendix titled invoice, and then I've ticked if an invoice is appended to the schedule. In claims that have been running for years, there are inevitably going to be receipts and invoices that can't be located. Sometimes the claimant might be able to prove that a payment was made by reference to a bank statement, and sometimes the claimant may have to estimate. This 3rd column won't be necessary in all schedules, but I added it in here as an option for you, as it is easier for both sides and the court to see at a glance which items have a corresponding invoice and which do not. And finally, with regards to past care, there is a very important point which is easy to overlook. We are preparing Penny's schedule on the 1st of February 2021 and serving it ahead of a joint settlement meeting on the 1st of September 2021. This schedule anticipates that the claim will settle on the 1st of September 2021. Any losses incurred prior to the 1st of September are deemed to be past losses. So you'll see that the 1st of February to the 1st of September is a sort of no man's land. These losses haven't happened yet, but they are claimed as past losses. And if you forget to claim them, you would be depriving Penny of 7 months of compensation, which she needs to meet the costs of her care. How you claim them depends on Penny's circumstances. If Penny's care arrangements are established and the care expert thinks that they will continue as they are until after the case is settled, one option is to take the average monthly cost of her current care regime and multiply it by 7. And you'll see that that is how I have claimed it in the example.
Of course, Penny suffered a very serious injury. and it's resulted in life-changing injuries that need lifelong care. And in that circumstance, the plan will usually be the provision of commercial care rather than relying solely on gratuitous care. So a new set of considerations are going to come into play, and a care expert report will really be a vital piece of evidence for us to rely on.
It's also important to note, and something that we've touched on a bit already, which is that a catastrophically injured person's future care requirements are likely to change over time as their symptoms either improve or worsen, or as comorbidities or age take effect. And so it's likely, as in Penny's case, and as can be seen in her care expert report, that the course of care are going to be different throughout different phases of Penny's life, depending on what she needs. That's going to require us to split multipliers, which, as Anna said, is something we touched on in seminar 1, if you need to go back and remind yourself.
The starting point for calculating future commercial care depends really on which care model you're going to be using for a given phase. Ben, could you tell us about an agency care model, please?
Yeah, absolutely. An agency care model is, you'll all be pleased to know, the most straightforward of the commercial care models. It can, though not always, also be the most expensive. And that's why you'll find that there's often a debate about whether an agency model is appropriate, or whether alternatively, in certain cases, whether a claimant should look to hire his carers directly. That's often called a direct hire or an employed model. You might want to think about the appropriateness of a care regime as being a little bit like a bell curve that depends somewhat on the severity of injury. So at the very lowest end of the scale, a short-term injury that resolves, gratuitous care is likely to be the most appropriate model. There are then those cases in the middle where it might not be worth the expense, or to be frank about it, faff of maintaining a direct hire model. And indeed, agency care might be more efficient in those circumstances. Some examples are where an individual perhaps needs just a cleaner or some domestic assistance, or in a brain injury case where there might be some ad hoc buddy assistance throughout the week. When you come to the catastrophic claims, well, you end up with very often with a hybrid type model. Agency care can be a really good way of getting a care regime in place quickly, because you can just go to an agency and it's not as easy as this. But with the click of the fingers and a lot of hard work, they can assemble the team to come into the claimant's home and provide what is required. It's also really flexible. So that gives you, particularly as a claimant set of solicitors and legal team, the opportunity to try different models, see what works, see what doesn't work with this individual claimant. However, doing that is necessarily very expensive because the agency takes a cut of any hourly rate that the claimant is claiming, with the remainder going to the carers thereafter. And so in most cases, you will look perhaps to trial regimes on an agency basis to start off with, and then move towards direct hire in due course. And indeed, that's exactly what Penny's care expert has recommended, as we'll see in due course. There are some exceptions to that rule. In certain cases, you may well be able to justify agency care on a lifelong basis. That may well be in circumstances where, for various reasons, there's likely to be a high turnover of care staff. You may well evidence that simply by what's happened in the past and the difficulty of retaining care staff in a certain geographical location. Or in certain circumstances, such as a case I had recently, I had a claimant with particularly profound behavioural issues. And to be frank about it, it was very difficult for those carers to remain in post long term, because the job was difficult and stressful for them. And so in those circumstances where you need a high turnover of rolling care staff, an agency model can on occasions be appropriate.
Thanks, Ben. And as you've said there, for Penny, for up until age 40, our care expert has recommended an agency care model. So we're going to look at how to calculate the cost of that. But before we get into it, briefly, here are the multipliers that are going to be relevant when we're looking at all of those different phases. The first one being that agency care phase. Anna, do you want to just briefly explain what's on our screen?
Yes, like you said, this is the multipliers page, and you also have reminded everyone that Dan showed you the table 36 method for calculating Penny's lifetime multiplier in webinar 1. And he then showed you how to split her multipliers for periods of care. Ben and I, for continuity, have adopted the time periods decided on by Dan, and that's how we've divided up the care report. I strongly recommend a separate tab in the schedule for multipliers, and I will show you why at the end of the webinar. Essentially, it's to make life easier for yourself if you have to make any changes to the multipliers further down the line. So the next slide is the calculation for Penny. It is very simple. The care expert recommends agency care for Penny until she's 40 at a cost of £1,350 per week. You simply multiply this by 52 weeks to get your annual cost, which is £70,200, and then you multiply that by your multiplier. On this slide, you will see that I have highlighted the multiplier box, which is D6. If you look to the top of the screenshot where it says equals multipliers exclamation mark G15, you'll see that I did not simply type 1.73 into the multipliers box myself. Instead, I pressed equals, I clicked on the multipliers tab, then I clicked on 1.73 in that multipliers tab, which is what pulled the 1.73 multiplier through into the future care tab. It's important you line things up in this way. And like I've said, I will demonstrate why at the end. And it's because if you have to make any changes to the multipliers further down the line, changing it once in your multipliers tab will update your entire schedule. And I'm sorry if this is obvious, but in the total box on your future care page, the total box here is E6. You need to ask the spreadsheet to multiply C6 by D6 rather than doing it on your own calculator and just typing the answer 121,446 into the box yourself.
Now, when Penny turns 40, the care expert has recommended a change to direct hire. Ben, could you tell us about the direct hire care model, please?
Yeah, absolutely. As I mentioned earlier, it's often cheaper overall in a catastrophic case. And the main single driver to that is the hourly rate, because you're no longer paying the agency effectively their cut. And so the hourly rates for care reduces accordingly, often driven by geographical circumstances. So you may find that the appropriate hourly rate in London and the reasonable hourly rate is higher than it might be in Kingston upon Hull, for instance, just to take two geographical examples of cases that I've got on my desk at the moment. There are two real quirks to a direct care model. The first is that there are 60 weeks in a year rather than 52. Now, that's not as odd as it sounds. Why is that? Well, firstly, your client needs 24/7 care, but the reality is that these individual carers can't be there 24/7. The individual carer may fall ill on occasions. They will require to go on holiday. They will on occasions need training. And all of that time off needs to be covered effectively by time from another carer. And what you find that happens in reality is, in fact, there's usually a team of about 6, 7, possibly 8 carers, all on a rota, providing 24/7 care. But that time off, the 28 days of holiday per year, plus around 8 days allowance for sickness, plus additional days away for training, means that if you require one carer to provide care on a 24/7 basis, the reality is that you will need to pay for about 60 weeks worth of carer time rather than 52 weeks. And so, whereas on an agency model, where the agency takes responsibility for all of those factors related to employment, and so you complete it on a 52-week year, from an employed model, it's 60 weeks. And that model has been endorsed by various cases, the first of which I think was XXX and a Strategic Health Authority, which we've cited there. So remember, 60 weeks in the year, not 52 weeks. Second core point is that you need to add in all the costs associated with employing the carers directly. So that can include national insurance contributions, often seen in care reports as ERNIC, pension contributions, running the payroll, and carers' expenses. Small things such as having a sandwich when out on an excursion with the claimant, so on and so forth. And they all feed into the schedule, which you'll see when you see our example.
And looking again at Penny's schedule of loss, how will this look?
Well, as Anna's been saying all along, the simplest and most straightforward way to do it is to simply mirror the care expert's calculations in your version of the schedule of loss. Much something else, it's as easy then for the defendant and the court to follow why you have come to the figures that you have come to. And so you'll see in the left-hand column what the care expert has said about the direct care model and the appropriate costings. And then those have been transposed into the schedule, which you see on the right-hand side. So you have in line 12, effectively the base costs, which are based on 7 hours of care a day at £11 an hour, weekdays going up to £12 an hour, weekends, which the care expert has calculated will cost £33,180 per annum. And then you add those additional expenses thereafter that I talked about. So you've got the two principles there, as you can see. Firstly, the 60 week year, and secondly, the additional expenses associated with employment. You then put those in as your multiplicands. As Anna's explained, you apply the split multiplier, copying it from the multiplier section of your schedule, and Excel works all the magic for you. And what would otherwise be quite a complicated exercise becomes very straightforward.
Thanks, Ben. So I notice that when we look at line 13, we've got national insurance, etc., on £24,756 rather than having it on the full figure for costs we have in line 12 of 33,180. Can you explain why there's that difference, just in broad brush terms?
Well, the easy answer is you don't need to worry about it too much, because an experienced care expert will do the calculation for you, and 9 times out of 10 you can take it as read that it's correct. But the theoretical answer is, in essence, this is just a tax calculation. And of course, everyone has a personal allowance upon which they do not have to pay tax. I think it's the first £10,000 or so at the moment. And so the ERNIC at 13.8% takes into account that personal allowance. So you are not undertaking calculations. This is 13.8% of £33,180. It's always going to be less than that.
Brilliant. Thank you very much.
Right, the next point we want to consider is that Penny would like to have a child. We asked Penny's care expert to address this, and she calculated the extra help that Penny's going to need to care for her child as a result of her injuries. That's on the slide in front of you. You can see how the care expert has set it out. Anna, how do we looking at this, how do we go from there to our schedule of loss?
So you will see that the care expert has created 3 extra care schedules, which will kick in if Penny has a baby. And this care is above and beyond the direct hire care model that Ben has just talked you through. So the way the care expert has divided up the additional need is the first year of the baby's life, then from age 1 to 4 inclusive, which means the whole of the child's 4th year up to the day before its 5th birthday, and then from age 5 to 14 inclusive, so the whole of the child's 14th year. Now, in order to plead this part of Penny's claim, you are going to have to split some more multipliers, and I have written the methodology onto this next slide. If you want to take some more time over it, pause the webinar here and just have a read through. So what we know is that Penny is going to incur a few years of losses, but the loss isn't going to begin until Penny has a child a few years into the future. To work out these multipliers, you need table A6 in facts and figures. It's on page 42 of this edition, and essentially table A6 has done the hard work for you. Now, hopefully you do have a copy of table A6 in front of you, so you will know what I mean when I say if you look down the left-hand column of the table, it says years of loss. And across the top of the table, it says years before loss starts to run. Childcare losses are as follows. The first year of the child's life. This is 1 year of loss, but it will not start to run for 3 years. So on table A6, you would go to the years of loss column, go to 1, and then you go across to 3 years before the loss starts to run, and you will see the number 1.01, and that's the multiplier that you use for the first calculation. The next period of time is from age 1 to 4 inclusive, so this is 4 years of loss, and they do not start to run for 4 years. So in the years of loss column, go down to 4, then go across to 4 years before the loss starts to run, and you'll see the number 4.06. That's your multiplier for the second time period. You use the same method for ages 5 to 14 inclusive, so that is 10 years of loss, which does not start to run for 8 years, and the multiplier there is 10.33. So that's how you get the multipliers for the years of childcare. And again, you set these out in your multipliers tab in your spreadsheet. One final point about this slide is you'll see from the description, I explain how to work these multipliers out if you don't have table A6. All that table A6 is a combination of tables 35 and 36. As you now know, Dan explained it in his webinar, table 36 gives the multiplier to use for a set period of time, a term certain. So here, the terms certain are 1 year, 4 years, and 10 years. Table 35 is the factor to discount a multiplier by in the event that a loss will not occur until X years into the future. So here it's 3 years, 4 years, and 8 years respectively. When you combine those two tables, it gives you your multiplier. Again, I would suggest that you read through the worked example on the slide in your own time. Then if we go on to the next slide, you will see that the tricky bit is working out the multipliers, and the claim itself is very simple to set out. You simply take the cost from the care report and multiply it by your new multipliers.
When Penny turns 50, it's anticipated that her care needs are going to increase inevitably. And in particular, in Penny's case, she's going to need double up care, which, as the name suggests, is where she'll have two carers, at least for some of the time, if not all the time. Now, before we look at the specific requirements that Penny has, Ben, what do we need to be thinking about when we consider the costs of double up care?
This can be a really controversial part of the claim, because if a claimant is able to establish the need for two carers rather than one, that necessarily doubles the cost of care over that time period. The need for double up care will inevitably vary from client to client. I always think, when I've got my claimant hat on, that a good starting point is the manual handling regulations. So if you've got a claimant who requires a lot of hoisting or turning at night, and you can get your case manager to arrange a manual handling assessment that says it is simply unsafe for those carers to handle that claimant on their own, then it will be hard for a defendant to argue against the principle that two carers are required. There are, of course, more nuanced cases, and a paraplegia case such as Penny's is likely to fall into that category, where you've got a claimant relatively young who can do an awful lot for themselves, and indeed a lot of paraplegics in Penny's positions find that they can be wholly independent in a number of tasks. But there may well still be those times of illness or particular activities that would require double up care. And there are various ways in which you can approach that. Again, you might decide that you're going to formulate your case on the basis that that care is a certain requirement at various times of the week and allow for double up care during those periods. Or you might add in a contingency for double up care over certain periods, illness being a prime example. The recoverability of all of this, again, comes back to the concept of reasonableness. A claimant, of course, is entitled to be put in the position that he or she was in prior to the accident, insofar as the court is able to do so through the means of compensation. Taking some examples, a claimant, of course, is entitled to live his or her life and engage in activities of their own volition and not at the behest of carer availability. As I had in a recent case, if a claimant needs two carers in order to interact with his children or her children, and that need can arise at all times of day, that can be another justification for double up care being available for 24 hours, even if the need per se does not arise for the totality of that 24-hour period. These are all important issues to explore with the case manager and explore with the case manager and care experts in conference. And this is where we as lawyers really earn our money, so as to ensure that the claimant recovers properly, if you've got your claimant hat on, so that their needs are appropriately met. And of course, similarly, if you've got your defendant hat on, ensuring that these needs are in fact reasonable, so as to protect the client's interests accordingly.
Thanks, Ben. And on the next slide, we've got Penny's particular example from age 50 to 60, when her care expert has advised she will need some double up care. So Anna, do you want to just explain how you worked this bit of the schedule out, which is Penny's phase from age 50 to 60?
Yes, there's actually very little to explain here, because you simply set out each item as per the care report, as we have done in the previous examples, and then use the age 50 to 60 multiplier, which is 10.43, and you have your future care costs calculated. For the sake of brevity, I just did one row in this example for the whole annual cost, when in reality, in my actual schedule, I would itemise it all as I have done in previous examples.
So that's considered all of Penny's needs up until she turns 60. But after that point, she's going to start needing care at night. Ben, what are the general points we need to consider when thinking about the cost of care at night?
Well, the core difference that needs to be considered, I suppose, whether night care is required at all, but in a case such as this, what one suspects likely. Then you need to look at the type of night care that is required. And that broadly falls into two categories. A sleep-in carer is the first category, or the second category being a waking night carer. A sleep-in carer essentially does what it says on the tin, is expected to be available, but is likely to spend the night shift essentially sleeping, perhaps getting up on ad hoc occasions to tend to a claimant's needs. A waking night carer, again, does what is said on the tin. That carer would be expected to get up on a number of occasions throughout the night to meet the claimant's needs. In fact, more likely would be awake for the night, looking after the claimant's needs. There is a threshold, really, that helps establish whether a carer is likely to be a sleep-in carer or a waking night carer. In general terms, when this point has been considered by the courts, it's been determined in this way, specifically that if a carer is likely to be disturbed more than 2 to 3 times a night on a regular basis, they flip from being a sleep-in carer to a carer who needs to be paid the full waking night rate. I won't get into the mechanics as to why, but essentially it's because from that point in time onwards, they're having insufficient rest under the working time regulations. The core difference in terms of quantification is that a sleep-in carer who is expected to be asleep will be paid 6 hours for a 10-hour shift on the basis that they're not paid for the periods where they can be expected to be sleeping. Whereas a waking night care is paid for the full 10 hours. So where there's a debate between sleeping and waking night, you're really talking about an extra 4 hours care per day, of course, 8 hours per day if it's double up. But that's the core difference.
Brilliant, thanks, Ben. Well, that leads us into our last calculation for Penny's care costs, which run from the age of 60 until her expected date of death. So again, Anna, this is relatively straightforward, but if you just want to explain what we're looking at on our screen.
Yes, just for this example, we chose waking night care. So the costings are for a waking night carer. And again, simply take the annual cost from the care report and multiply it by the rest of life multiplier from your multipliers tab, which for Penny is 16.14.
Brilliant, thanks, Anna. And that brings us to the end of care costs. And now we'll move on to case management costs.
Ben, what is the role of a case manager? What do they do for the injured client? And how will those costs be reflected in the schedule of loss?
Well, in a catastrophic case, a case manager is absolutely instrumental. They will come from a variety of backgrounds. Some will be occupational therapists, some might be physios, some might be nurses, some might be social workers. And they will have experience, if you find the right case manager, of dealing with specific types of injury. So some may specialize in spinal injury, some may specialize in brain injury, some may specialize in injuries to children. And what they really do is take that level of expertise and organize everything, or manage the case. That will include setting up the care package, setting up therapies, setting up a rehabilitation programme, managing the carers on site during the earlier stages of a care regime, with twofold benefits, really. The first, obviously, is to take the pressure off family members, who, of course, are very often will not have experienced anything like these events in their lives before. So they don't have to face the additional burden of dealing both with a catastrophic injury and managing a regime which that they are not expert in. And secondly, just that to gain the benefit of the expertise of the case manager. And as Anna was saying earlier, where you are looking to trial things and see what works and what doesn't, case manager can be absolutely instrumental in that process. So that's roughly speaking what they do. And then they stay with the claimant after the case is settled as well, so as to ensure that the care package is maintained and those therapies and rehabilitation continues.
Thanks, Ben. And how's that going to look for Penny's case specifically?
Well, once again, a good care expert will do the job for you. So you can see here in the left-hand column, and these figures are all taken from a typical care report. You've got the recommendations of the care experts in respect of case management. This is entirely typical, where you have a lot of case management at the very start. That's often when you're settling a claimant into their new home and getting the care regime in place. And then that will taper down to what might be termed as a maintenance level of case management once things have been set up. So it's not unusual to have year one costs that are quite high, year two costs a little bit lower, and then costs for the rest of life running at a lower rate again. And it's a simple calculation, number of hours times an hourly rate plus expenses to give you your multiple cans. And then you split the multipliers in the appropriate way using the methods that have been explained by way of reinforcements time and time again, both in the first seminar and this seminar.
Thanks very much, Ben. And now, before we finish off the seminar, let's just quickly look at periodic payment orders, or PPOs. In brief, a PPO provides that the defendant will pay the claimant an agreed sum, usually on an annual basis, until the end of her life. Anna, can you tell us about using PPOs to settle a claim like Penny's?
Yes, as you've said, a PPO provides an annual payment for the claimant for the rest of her life. And it removes the worry about making a lump sum payment for care based on an estimated life expectancy stretch if the claimant outlives the estimate. PPOs will continue for however long Penny lives. The index used is ASHE 6115. ASHE stands for the Annual Survey of Hours and Earnings, and index 6115 is the survey of carers' wages. The percentile you link to should be the percentile of earners that most closely approximates to the hourly rate awarded by the court or agreed by the parties in your case. But in reality, it will almost always be the 80th percentile that is used, and that is what we will use for Penny. Penny will need to take advice from an independent financial advisor before making her choice whether to claim a lump sum or a PPO for her future care and case management. And if she does opt for periodical payments, her annual payment will be the 15th of December each year. Next slide, please, Karen. So in practical terms, calculating the PPO. When you've finalised your schedule, which, as you know by now, we have done for Penny on a lump sum basis so far, you need to remove the lump sum claim for future care and case management. In Penny's schedule, it's over 4.2 million. Assuming this is the only part of her claim for which periodical payments are sought, what remains in your schedule once you remove this will be your baseline lump sum. Now, in keeping with our Back to Basics brief, all you need to know about the claim for periodical payments, assuming that the claim was settled on the basis of Penny's schedule as drafted, is that from age 40, Penny will receive £41,346 per year. She'll receive £82,042 per year from age 50 and £134,533 per year from age 60 for life. There is a final slide which we are not going to go through today, but if you want to know how to divide the PPOs to reflect that Penny turns 40, 50 and 60 in the May of each year, but doesn't receive her increased PPO until December of that year, just read through that slide at your leisure. And in terms of the additional care payments during the childcare years, you can choose to claim them as an increased periodical payment once Penny has had her child, or you can negotiate that part of the care claim as a lump sum payment. One final point is that a key trap not to fall into is to fail to claim as a lump sum payment the amount needed for care and case management between the date of settlement and the first PPO. So on the next slide, this is the calculation which fills that gap. Penny's case settles on the 1st of September 2021. It's 105 days until she will receive her first periodical payment. The amount she needs for care and case management in the first year is £89,960. So if you divide this by 365, that tells you the daily cost, and then multiply it by 105 to show that Penny will need £24,440 as a lump sum for her agency care to tie her over until the periodical payments begin in December.
So as already was discussed in seminar 1, Dan certainly prefers to use Excel rather than Word. But Anna, I can see on the screen now we've got your spreadsheet. Could you talk us through the advantages that you find with Excel?
Yes, all my schedules are prepared in Excel. You'll see this is the summary page. If I hover over the future care and case management, you will see in this box up here that it has been linked to the future care and case management tab. This is the multipliers page. Dan took us through the table 36 method for calculating the lifetime multiplier. You'll recall he also touched upon the table 2 method, and Penny's multiplier before interpolation would have been 37.96. So let's say you're in your JSM and the defendant wants to use 37.96 as the lifetime multiplier, and you want to see what difference that makes to your costings. In your multiplier tab, you simply have to change the lifetime multiplier to 37.96. And if you keep your eye on row 18 from age 60 for life, when I press enter, you will see that changing the lifetime multiplier will then change your final split multiplier. I will change it back for a second while I show you the future care and case management tab. You will see in the section for age 60 for the rest of life, your multiplier box is linked to your multipliers page, and it was 6.14 in our schedule. Now what happens if you want to tap in 37.96? you will see that it has changed the multiplier to 15.64. It's therefore changed the total because you had it set up to do the multiplication for you. It's changed the total here. It will have changed your total for care there. It's also changed that to 4.1 million from 4.2 million. And then if you go to your summary page, it has pulled your new total through so you can see what your new lump sum is. That is why it's so important to just have all your tabs lined up and your formula set up correctly, because all I had to do was change that one number in this box and my entire schedule has recalculated itself. And as well as how easy it makes it when you're in negotiations and numbers are flying back and forth, you need to be able to do that really quickly and tell your client what difference a defendant's offer has made to the total value of their claim.
Great. Well, thanks so much for that, Anna. I think that was a very useful and really clear demonstration of why Excel is so much better for this than Word would be. Typing in the number in one place and everything feeding through, certainly far preferable to trying to do those calculations again from scratch and typing them in on every part of a Word document where it fed in. And thanks again to you both to Ben and to Anna. That was a hugely interesting and hugely useful presentation from you both. I know I've learned an awful lot just by doing this recording from you, and we're all incredibly grateful for your time. So thank you.
Absolute pleasure.
Very welcome. I'm a huge schedule enthusiast, so it is no problem at all for me to try and share some knowledge.
Anna, show everyone your mug. There we go. That's what you need to know.
We've got to get some Schedule School merch, and that's going to be first up. Yeah, but thank you both so much. And like I said at the beginning, Anna and Ben have produced this Excel schedule for us. It's up on the website. So is the care report. So you can use those at your leisure. So please do use them. And also, if you have any questions or comments or feedback from today, please do find us on Twitter. I'm at Hunt Karen and Ollie is at Omay Days. So please let us know what questions you have, what feedback you have, and stay tuned for the next seminar in Schedule School, which is going to be all about aids and equipment, so not one to miss. Thank you again to all our guests, and goodbye.